A man consented to his estranged wife's in vitro fertilization, or IVF. Did his consent to the procedure make him the legal father of the resulting twins, even though he consented on the condition that he wouldn't be legally or financially responsible for any child? In Okoli versus Okoli, the Massachusetts Appeals Court had to decide. Married couple Chukwudera and Blessing Okoli struggled to have children for several years. When they separated, they were on a waiting list for donor eggs, which they had planned to combine with donor sperm to create embryos for IVF. The next year, donor eggs became available, and Blessing asked Chukwudera for his consent to start the IVF process. Although Chukwudera was hesitant at first, he eventually signed a written agreement with Blessing consenting to her IVF. The same agreement said that Chukwudera wouldn't be legally or financially responsible for any child, and that Blessing wouldn't ask or sue for child support. Several rounds of IVF later, Blessing became pregnant and gave birth to twins. Several years later, the Okolis officially divorced, and the probate and family court ordered Chukwudera to pay child support for the twins. On appeal to the Massachusetts Appeals Court, Chukwudera raised 3 arguments. First, he consented to the IVF on the condition that he wouldn't be legally or financially responsible for any child, and his conditional consent was insufficient to make him the twins' father under Massachusetts law. Second, he only consented because Blessing threatened to stop supporting his U.S. citizenship application. And third, Blessing forged his signature.